Hi, my name's Jim Dawsey, and I'm an attorney at Dawsey and Jones Law Firm in Conroe, Texas. And I'm also a CPA. Um, and today we're going to talk about the Corporate Transparency Act. Um, I'll go a little bit today, uh, go into some of the law itself, how it came to be, and some of the particular things you should be aware of. And then really the focus of today is going to be on how do you actually submit the reports. So to the extent possible, we'll try to stick to practical things. I'll keep the presentation moving along pretty good, but if you have any questions, um, and go ahead and jot those to the meeting chat, and I'll try to answer them as I go. If not, I'll get them at the end. So we'll try to answer all the questions that we can. Bear in mind, a lot of this is still in action. We're still learning a lot at this point, but uh, but we try to answer everything that we can. Okay, with that, let's go ahead and get into the presentation. So as I mentioned at the beginning, we're going to talk about the law itself and how it came to be, what entities are going to be subject to the Corporate Transparency Act, what things you're going to have to report and how to report them, and then any kind of penalties for non-compliance. So talking briefly about what is this Corporate Transparency Act, this actually came from European law. Anytime you form entities in the past that I've had done for other clients, forming entities in other countries, you have to provide a lot of information on the owners of those entities, passports, driver's licenses, even copies of bills and things like that. We've never really had that here in the United States, but apparently the United States has become a hub of money laundering, and so this law is meant to curb some of those bad actors that are using our system just because we don't provide that kind of information. And so that's where this has really come from. The entity that is in the government that is kind of managing this is called FinCEN, Financial Crimes Enforcement Network. They're actually under the Department of the Treasury, and so you can kind of think of them as a sister organization to the IRS. So let's talk about who this actually applies to. Basically, there are some limited exceptions, but for the most part, the Corporate Transparency Act applies to almost every state filing entity. And we'll go through the exceptions, but if you think about the normal entities that you may have yourself or created for clients, this could be a single member LLC that's used for consulting. It could be a partnership that's set up for real estate transactions. It could be a corporation, a small corporation that is set up years ago that has an operating business. All of those potentially are subject to this new law. FinCEN provides a frequently asked questions section on their website. And so if you Google FinCEN BOI reporting, you can go to their website, and it actually is pretty good and informational. They have a frequently asked questions section that's very good. And this is a chart from that section. Basically, what it's saying is if you are a corporation, LLC, or any kind of filing entity, you're probably subject to this new regulation. And that's also foreign entities as well. Let's talk through some of those limited exceptions. Trusts generally are not reporting entities because trusts generally are not, you don't file those with the state. There are some exceptions to that, limited exceptions, but those are very rare. We'll kind of get into some of the details around that are a little bit unique. Some of the other exceptions have to do with entities that are also already very regulated. So things like insurance companies, banks and credit unions, securities, government entities, those are all entities that have significant filing and reporting requirements already. And so they're not going to be required to file under the CTA. Some other exceptions, general partnerships. When you have a general partnership, generally you are not a filing entity. So a general partnership is you're formed just by getting into business with somebody. You don't have to file with any kind of state in order to create it. So it's not subject to the Corporate Transparency Act. Something called an inactive entity. And this is a very limited exception. Basically, the entity has to be formed before 2020 and have less than a very minimal amount of transactions through it. So when you go into the actual rules of what this inactive entity, the definition is, it's actually pretty limited. Tax exempt entities, so charities, churches, schools, those are all also non-reporting entities. So we don't have to do the CTA for those. And then finally, what's called a large operating company. Large operating company means you have to have at least 20 employees and it has to have over $5 million in revenue, just kind of as a general rule, both of those things. So you can have five employees and $30 million in revenue, and you still have to file with the CTA. You can have 40 employees with 10 million in or 2 million in revenue, and you're a filing entity. So it's both of those requirements: 5 million in revenue, 20 employees. It's a large operating company. There's also some important concepts to keep in mind. One is what's called a company applicant. This is the person that actually files the entity with the state. Information on the company applicants also is provided for each entity. And we'll kind of get into what exactly that information is, but the company applicants themselves have to be reported. So this could be the person that actually filed the document with the state. So in a law firm, that could be the attorney, the managing attorney, and the paralegal that actually filed it with the state, or it could be an administrator that helped the CPA file it. It's everybody that's potentially involved in the filing process. So it could be more than one. Okay. There's also this concept of what's called a beneficial owner. Beneficial owners is actually a little bit broader than you might think. It's anyone who directly or indirectly, through any contract, arrangement, understanding, relationship, or otherwise. So doesn't necessarily have to be ownership. If they're directly or indirectly involved in management, essentially. If they exercise substantial control of the company. So if you think about like a CEO that you hire for the company, even though they may not own any of the company, they're still a beneficial owner according to the definition. Or it could be someone that owns or controls at least 25% of the ownership interest of the reporting company. So this can get a little bit more complicated than you might think. So this slide here also comes from the frequently asked questions on the BOI, FinCEN BOI reporting site, but you can kind of see it's broader than you might think. It's anybody that has any kind of control over the company, anybody that has significant decision-making capability. And this has to do with ownership. So it's not necessarily just direct ownership, it's indirect ownership as well. So this could be somebody that owns 25% of the company, or it can be somebody that owns a right to owning 25% of the company. So convertible instruments, you think about convertible debt. That debt holder isn't an equity holder in the company, but they have the right to become an equity holder. Options, people that have options to buy shares in the company. Profits interest, these are kind of like options for an LLC. So you can kind of see it's much broader than you might think as to who actually is going to be included in this concept of a beneficial owner. Something that's come up very recently, actually, this was something that I realized just yesterday because in preparation for this talk, I was going to do a couple of filings on my own. So I have a couple of LLCs that I own personally, and I was going to go through the filing process so that I could talk to you guys at length about how actually the process works. And so I have an LLC, I'm married, and I have an LLC that's just in my name. So I'm filling out the paperwork in the BOI report. And I'm thinking, okay, well, I own it on paper 100%, but my wife, we're in a community property state. Technically, she has a community property interest in this property. So is she also a beneficial owner just because we're in a community property state? The answer is yes. So after doing a little bit of research on this, it includes not just the beneficial owner themselves, but it's anybody that has beneficial owner through joint ownership with one or more persons of an undivided interest. So if you think about all of the beneficial owners of a company, say you have 5 owners of the company, and you're going to have to ask each one of those people, are they married? Is this a community property state? If they're in a community property state and they're married, well, they have a community property interest, but you're going to have to ask them, is it community property or is it separate property? Because it can be different depending on each individual person. So this can get really complicated, as you can probably imagine. Say I have a husband that owns 100%, like me, of an LLC. I'm going to have to ask that owner, number one, are you married? Number two, is this a community property state? And number three, is this community property? So something that every one of us is going to have, that's helping people to do these filings, is going to have to come up with their own process and understanding of, is this something that we really want to get into with the client? So when I've done some research on this, this particular question is kind of my bread and butter as an attorney. So I know these answers, but as somebody that's helping clients that maybe isn't an attorney, I highly doubt that you really want to get into trying to classify whether something is actually community property or not. And so one of the suggestions that I've seen from other practitioners is, okay, maybe coming up with some sort of certification that the owners will provide to you. They have to tell you whether it's community property or separate property, and have some sort of sign off on them so that you can have some paperwork to show that they told you it was community property or they told you it was separate property. And so you won't be held responsible for that. Okay, the second kind of potential issue is dealing with trust. And this one is a little bit near and dear to my heart because I'm an estate and tax attorney and also a business attorney. So I do a lot of estate planning for people with trust. So trusts in and of themselves are not reporting entities because you don't technically, very rarely file them with the Secretary of State. But they can be beneficial owners. So a trust can own more than 25% or have a controlling interest in a company. In that case, the trust is a beneficial owner. And so you're going to have to provide information for any of the beneficial owners, which might include the trustees. So the trustees of a trust, It could be beneficiaries if the beneficiaries of the trust are able to have a right to take out all the income and principal of the trust. It could be a settlor or grantor. If you think about a revocable trust that can be revoked at any time, they could take that interest back. So that settlor or grantor would be a beneficial owner. In some cases, it could be a trust protector or a special trustee. If that special trustee or trust protector has a right to dispose of the trust assets. So in those cases, you would need to go into the trust document and understand who actually has these kinds of rights within the trust. And that's going to be some analysis that has to be done there. Okay, so let's kind of go into some of the reporting stuff. This is the information that has to be provided for each of the filing entities, the beneficial owners, the company applicants. And that's the key information. So if you're looking at the reporting company, it's going to be the legal name, any DBAs, addresses for the principal place of business, the EIN, where it was formed. Then for each of the company applicants and each of the beneficial owners, and you're also going to have to provide, excuse me, the following information: the legal name, the date of birth, the current residential address for the beneficial owners. For company applicants, it can be the business address, driver's license number or passport number, and an image of that document. So this is for every single one of those company applicants and beneficial owners. FinCEN has tried to come up with a shortcut, and that's called the FinCEN identifier. And the idea behind this is if you, so that you can imagine a lot of our business owners have multiple entities, and to provide the same information to each entity, number one, that's private information and confidential information that they wouldn't want to give everyone. But number two, it would just be a lot of effort. And so to kind of short circuit that, the idea of this FinCEN identifier is a business owner or a beneficial owner can create a FinCEN identifier, provide their contact information, their passports, all that to FinCEN, and get a unique identifier. And that unique identifier is then provided in the reports. So that's the idea of it. When I was going through the reports yesterday, there's actually no way in the reports to provide a FinCEN identifier for a beneficial owner at this point. So I assume they will have that fixed, but right now that's not able to be used. Okay. One of the key things about the FinCEN identifier that I think, again, part of the idea is that if any of the information changes, so at the company level, at the reporting company level, address, probably not much will change. Ownership might change, but information about the company itself. But as you can probably imagine, the individual owners, you have people moving all over the place. They change their addresses all the time. Maybe they get a different passport or a driver's license. If there's any change, that has to be reported within 30 days. So from a company standpoint, it's much better if you're able to provide the FinCEN identifier for that beneficial owner with the reporting for the company, and then the individual owner, the beneficial owner, handles their own changes with FinCEN. So from a company standpoint, it's going to be much better to have your beneficial owners provide their FinCEN IDs than you to have to manage that going forward for address changes. All right, let's talk about when the reports have to happen. It depends. So for existing entities, these are entities that were in existence before January 1, 2024. Those have to be filed this year by January 1, 2025. For new entities, so entities that that were formed during 2024, those have 90 days to be filed. After 2024, it's a 30-day turnaround. So it's a lot shorter. It used to be 30 days for both, but because this is a new law, FinCEN has given us 90 days for 2024. If there's any changes, as I was mentioning before, to beneficial owner information, then those changes have to be re-reported within 30 days of the change. So pretty tight timelines for that. Okay. One question that has come up very recently is whether BOI reporting is the practice of law. And I know that there was also a question in the chat whether this was the case or not. At this point, it's still unclear. The FinCEN on their website, they have a frequently asked questions section, and it says on the frequently asked questions section that attorneys or CPAs, either one of them can help and assist clients in preparing the BOI report. But as you can probably see from some of the slides that I provided earlier, analysis on what a beneficial owner is, who they are, community property issues, trust issues, it can definitely skirt the edges of law, but that issue has not been decided yet, mainly because it's too soon. The one thing I would say is that we are hearing that a lot of CPA firms, when they're contacting their insurance providers are not covering it under their insurance because some of the insurance companies are considering it the practice of law. And so we've actually had several CPA firms decide that they are not going to be providing this service because of that. But again, I think you would need to just check with your own insurance company and your own attorney to understand whether that's something that you want to do. The AICPA has provided some kind of information or provisions that you can add to your engagement letters, which I think are pretty good. If you're not going to do the CTA filings, it's kind of a blurb that you can add to your engagement letter that would basically a CYA on you're not doing it, but they need to go find their other attorney or somebody else to help them with that. Okay. That last section there was from again the Journal of Accountancy, which is a very important source. And again, really, this is just we don't know yet is the big answer to that question. Okay, so let's kind of talk about how we actually report. So there is so this is the actual FinCEN website, and so you can go out to it. You can Google FinCEN BOI reporting, and it'll probably be the top one in the checkbox, and so you can go out there and Google that, and this is the website that you'll see. You'll see right on the front page where it says file a report using the BOI e-filing system. And so you would click to that. You could create a FinCEN identifier. So you can, there's two choices there. So you see that down there on that same website. Once you click on that first link where it's talking about the BOI reporting website, it will take you to the second page, which you would just click on that top BOI e-filing button. And then there's going to be basically three choices on that page. One is going to be to file using a PDF. And I did this yesterday just to try it out. Basically, you click on this button to do it according to a PDF. A PDF will launch on your computer, which is pretty self-explanatory. It has a series of buttons, so it's kind of a smart PDF where it will go through and it has some error checking to it. The information is pretty self-explanatory. And so you fill this out and you save it. And then once it's saved on your computer, you can then upload it to the system. The second way that you can do it is straight into their online system. So there's basically three choices. One is the PDF. The second is what's called, it's just their online filing system. And then there's a third choice, which is an API, which most likely won't apply to you, but I'll show you what that is. The second one here is the online system. And again, this is pretty straightforward and self-explanatory. The reports are pretty easy. Just from trying it yesterday, I actually went through both the PDF and the online reports. Probably the most difficult part is that first part is gathering the information and knowing what to report. It's not the actual report itself, if that makes sense. And then finally, there is this API option. API is what's called Application Programming Interface. And so the idea being that some software providers will be able to directly upload your BOI information directly to the FinCEN database. And so we have a side venture called VentureVault that we are doing this very thing. So we are in contact with FinCEN to develop our connection with the API so that we can directly upload information to FinCEN. Okay, what happens if you don't comply? Basically, there are pretty stiff civil and possible criminal penalties for noncompliance. So on the civil side, $500 a day, potentially, and on the criminal side, $10,000 and up to 2 years of imprisonment. So they are very serious. Of course, I haven't heard of anybody yet that's been tagged with this, but nobody's had to comply yet. So it'll be interesting to see how strongly they go after people that are out of compliance. I will say that the whole point of this is to catch the bad guys, the money launderers, the drug dealers, and all those people, the bad people. But who knows? Okay, so what to do now? The main thing that I would say is first you need to start preparing, and that preparation is gathering the information, especially if you are preparing these reports for other people. So one of the things that we have seen, we already have a backlog of probably 200 to 300 reports to file for some of our clients. And so as you can imagine, that is a lot of paperwork and information that has to be gathered. So if you're a CPA or an attorney, you can kind of imagine, first you reach out to the client, tell them about the CTA requirement, explain what the law is. They send you the client sends you the information. Half the time it's going to be wrong. Then you're asking for more information and then filing the report. So there's definitely a lot of back and forth that has to happen. So get on this early. The other thing I would say is please try to do this as early as possible. So what we've been telling our clients is We have formed thousands of entities over the years, and I would imagine we're probably going to do most, if not all of them. Each one of these is probably going to take at least an hour or two once you get through the information gathering and the reporting. And so that is a lot of man hours, if you can probably imagine, 4,000 to 5,000 at least. So for me, that's several people that are doing this nonstop all year. So I would encourage you to please report early and not to wait until the last minute to try to get to your lawyer or CPA to do these filings, because we are going to get crushed at the end of the year. I guarantee it. People will put it off, and we will get crushed. So anyways, preparation, getting it done now, and then we also offer, as I was mentioning before, Venture Vault, which is a third-party software that we own that will help with the filings. And just to give you a little bit more information about what this Venture Vault is, basically it's a online portal where we store documents, we file the CTA information with FinCEN, we act as a registered agent. Coming soon, we're going to do a public information report. So it's kind of like an online business entity protection plan, for better, lack of better words. Okay. The other thing I would say to that is that we do offer a affiliate marketing program. So if you are a CPA or a financial advisor or an insurance person, and you want to refer clients to Venture Vault, we'll handle the filings, and then basically send you a QR code that you can send it directly to your clients, and we pay a fee for that. Okay. At this point, I am going to open it up for questions. Let me see if I can get the, go ahead and get the chat opened up. Okay. All right. We have 32 questions in the chat. So let's see if we can. Okay, so we talked about, first question there has to do with CPA preparing the form for the client, but the client actually remits it to FinCEN. Is the CPA practicing law? Well, I would say, as I was mentioning before, I think that that's a little bit undetermined at this point. My sense is that the filing itself is not really the practice of law. The practice of law would come in at the beginning of the process, where you're trying to figure out who the beneficial owners are, and you're advising the client on who should report and what should be reported. Okay, next question. A good engagement letter, please let me know. Yes, as I was mentioning before, the AICPA has provided a sample language for an engagement letter that I was trying to get my hands on before the meeting, but I couldn't find it. But it's available, and if somebody wants to provide that to me or send it over to me, I can then provide it to the group if needed. Okay, third question. If you have zero revenue, do you have to file? Yes, you do. So it really depends on if you are one of these dormant entities that I was mentioning before. So, and it does not have to do with zero revenue. So you can have an entity that owns property, for example, and it doesn't have any revenue at all, but that is not a dormant entity. Dormant entity is very, the definition of that is very limited. Basically, it can't be doing business since 2020, and it can't have more. Just not having any revenue does not qualify it as a dormant entity. Okay. Question about the family attribution rules in determining beneficial owners. Uh, so I know where you're going with that. Family attribution rules related to the tax code. Um, I have not seen anything related to that in the rules are not directly related to the tax code, so they're not transferable, if I would say that. But I have not seen that happen yet. But I would say that's still unknown. Uh, we will be releasing this video and the PDF to everybody after the call. So I saw some people trying to take pictures of the slides. Don't worry about that. We will be sending this out later, so you'll have all the information. Okay. For large company exception, can we have an aggregate or an affiliated group? And no, so it doesn't work like that. When you have, so under the tax code, there are consolidated companies based on ownership, subsidiaries and things like that. That rule does not apply for this beneficial owner rule. So you have to analyze each individual filing entity to know who the beneficial owners are. And each one of them could be a filing entity. Okay. So it's still some of the same questions. If a trust owns more than 25% of a limited partnership, who's the beneficial owner? The trustee or the beneficiaries? What if it's not clear that the beneficiary has an interest greater than 25%? Well, if the trust owns more than 25%, then the trust itself is not a beneficial owner, but the trustee probably is. The beneficiaries might be, and so you would have to look at the trust agreement to understand who has the authority and who has basically control over the assets within that trust. Do you only report individual owners, or do you have to report the business owners as well? So if you imagine you could have a LLC that is owned 25% by another LLC. Well, that 25% by the other LLC would be a business, a beneficial owner. And so you would report that as a beneficial owner. And you might have to go down to the next level when you report that owner, the LLC, this subsidiary of the main entity. So you could have to go pretty deep on that. Okay, what if the LLC is organized in a state that's not community property, but the owners live in a community property state? So this could be, so say you have a Delaware LLC that's owned by Texas owners. Well, the community property issue is an individual owner issue. It is not a company issue. So you have to analyze that at the individual beneficial owner level. So you have to go to each individual beneficial owner and do that analysis. So it would not be at the LLC level. Does the community reporting issue apply if a married person is an officer director of the entity? I don't think so. It doesn't seem like that would be the case. I don't know that I haven't seen that question raised. Most of the time it has to do with the community property issue has to do with the actual ownership, not who's in substantial control. My sense is that it would not apply. But we're still learning on that. Is there any problem if we err on the side of reporting more beneficial owners than may be required just to be safe and report more than less? No, as far as I know, there's no downside to reporting more than less. And basically everything that I've seen, the general recommendation is to report more to be on the safe side. So if there's any question, because the laws are so new and we're still learning and there's still a lot of questions about things, to be on the safe side, err on the side of safety. Seems unconstitutional. There's a lawsuit, and if the lawsuit is still in progress, there's all kinds of challenges to this rule, as you can probably imagine. But at this point, we have to deal in what we know. And what we know is that this law is in effect. Actually, one of the things that we were thinking and really not knowing what was going to happen, the AICPA and others have challenged the rule last year, September, October timeframe. And basically FinCEN came out in December and just told everybody to stop crying, that this is a real thing, you're going to have to comply. Where it actually ends up in the courts, who knows? But what I will say is that we know that as of this point, you need to comply with the law, and hopefully for everybody's sake, we don't have it forever, but that's what it is. Okay, if a DBA has been terminated, I assume you don't report it. I'm not sure about that. So DBA, you're supposed to, in the FinCEN report, the DBA is a information that has to be provided with the FinCEN report. So if a new DBA is created, or if a DBA has been terminated, no longer used, I'm not sure about that, whether that has to be reported or not. Open question. What if the company has not been ended with the Secretary of State? I didn't see anything in FinCEN to say that it wasn't in existence anymore. So I'm not sure about that. One question that I have been getting a lot recently is, what if I terminate my entity in 2024 before the filing deadline of January 1, 2025? Well, I have not seen any answers to that questions. My sense is that the deadline for existing companies is January 1st, 2025. So if you terminate the entity in 2024, I can't see how that would be required that you still file it for 2024. Okay, Texas driver's license expiring and then reissuing under the same number. Would that require a change in report? I don't think so. The number itself, I would say, as long as the number itself doesn't change, then that's not a change that would have to be reported, because people's IDs expire and have to be revisited all the time. So I would not say that you would need to do that. Okay, same thing with the renewal of the passport. Unless some of the information actually changed. Does the managing member make the report for an entity and for each? Okay. Does the managing member make the report for an entity and each 25% share owner is a beneficial owner? Then each beneficial owner gets a FinCEN identifier for each entity report. So basically, the person that is the entity itself is in charge of making the report. It will go, so the entity is responsible for reporting that. So you're gonna have to go out to each of the beneficial owners and ask for their information. If they provide you a FinCEN identifier, then great, that's all that you need. If they don't have a FinCEN identifier, then you're gonna have to get their home address, their full name, their phone, their date of birth, copy of their passport or driver's license, and the driver's license and passport number. Okay. if I have a company that's an LLC, but we have revenues greater than 5 million and more than 20 employees, we would not have to report under this law, correct? Yes, that's correct. Okay. How do we refer clients? As I was mentioning, if you are interested in us helping you with this, then we can just contact us. We'll give you a QR code that you could then send to your clients, and it will refer them directly to us and tell us that they were sent by you. Okay. I filed a few reports that did not include the community spouse as a beneficial owner. Should I revise and update the report? Yes, I would say so. And this is actually the same boat that I'm in. So I filed this report yesterday. And then afterwards, this is when I came to this realization about the community property issue after I'd filed my own report where I was the 100% owner. So I'm going to have to go back in and make and update the report to include my wife's information because she's under community property. She owns 50%. How long does it take to get a FinCEN identifier? It's really a very simple process. So the FinCEN identifier, maybe 5 minutes. Oh yeah, I see somebody else answered that as well. Okay. What kind of documentation do you provide for a business owner in place of a driver's license or a passport for an individual? That's really, as far as I know, that is primarily what they're asking for is a driver's license or a passport. I don't know that there's any alternatives that are available in for this FinCEN reporting or not. I can look into that, but I'm not sure. Okay. What if the LLC owner is a foreign company? It's also a filing. That LLC is a filing entity, so the FinCEN report would have to be filed for that. If you have a series LLC, do you report on all series or just the parent LLC? My sense would be that the series LLC itself is just one entity, so one CTA filing. And I see that Paige had answered that as well. If there's a change or you discover an error in the updated report, refiling everything or just report the change or error correction. Basically, it depends on what the error is. So my sense is that you would have to refile the report itself with the corrected information, the entire report. So if you do a PDF, so if you use the PDF version of the filing, you can actually save that off and then make changes to it later and change it to a changed filing. Okay. For a disregarded entity, LLC should report the LLC's federal EIN or the owner's ID. So for a disregarded entity, if it doesn't have an EIN, then you can use the Social Security number. I actually did this for one of my entities yesterday, just to try it out, and it works. A lot of times, whenever we set up entities, we'll get an EIN anyway, but you don't have to for a disregarded LLC. Okay, if you report more beneficial owners and then find some are not beneficial owners, how do you get them off the paperwork? I would say you can just refile the report as an updated report. If the LLC is a beneficial owner of a limited partnership, what kind of documentation for the LLC would you need to provide? I'm not 100% sure on that. The LLC itself could get a beneficial owner, a FinCEN ID, I believe. Let me check into that and get back to you on that. I'm not sure. Okay, what about entities whose charters lapsed due to not filing franchise reports and haven't been officially terminated with Secretary of State? I would say that those are still filing entities. If they are, unless they're just totally gone, they're terminated. If they're terminated, then they're not a filing entity. Okay, I see that Paige has answered some of these. Pricing a Venture Vault, get with Carly. She's carly@dawsey.com. See if there's any other questions here we haven't gone through. Okay. I will also double check on the expired driver's license and passport issue. Beneficial owner is a minor. There are exceptions for that. And so basically you'd be filing as a legal guardian. Okay, I think I'm running out of steam at this point. I really appreciate everybody joining the call. And we will, as I mentioned before, we will provide all this online. We'll send out this presentation and the recording of this presentation to everybody on the call. And you can forward it to the extent that you want. So all freely available and happy to answer any questions that you have. Thank you so much, everyone.